My name is Fran Hoffinger. I'm the chair of the City Bar's Council on Judicial Administration, one of the sponsors of tonight's webinar. The other co-sponsors are the State Courts Committee on Judicial, State Courts of Superior Jurisdiction, the Civil Courts Committee, and the Criminal Courts Committee. I'm going to introduce our moderator, Mr. James Chou, who, in addition to being a partner at Morit, Hock, and Hamroff, is a member of the CJA, a member of the City Bar's Board of Directors, and a member of the subcommittee who prepared the report. With that, I'm going to turn it over to James.
Good evening, everybody. Thank you for joining us this evening. I'd like to introduce our distinguished panel. First, we have the Honorable Andrea Masley, Justice of the New York State Supreme Court, New York County Commercial Division. The Honorable Stephen Barrett, retired Supreme Court Justice, Bronx County, criminal term, and Mr. Robert Newman, staff attorney at Legal Aid Society in New York City, a member of the CJA and the Constitutional Cap Committee, which authored the report that we're going to be discussing tonight. We're here tonight to discuss the report that this subcommittee authored and that the City Bar recently published, proposing a new approach to assessing the needs of our courts in the state. And the report makes a number of legislative proposals, which we'll get into shortly. But before we get there, I think it's important to discuss some of the premises of the report. The first is that the current state of affairs of our courts in New York State is dismal. There are not enough judges to meet the needs of litigants in the state and to do justice, whether on the civil or the criminal side of the system. The population-based constitutional cap is one of the root problems, the cap being the current method of calculating the number of state Supreme Court justices under our state constitution. And the cap hasn't been updated since 1967, and its inadequacy has led to several makeshift measures to populate our state's court to meet its increasing need. So with that, let's talk about the current landscape and set the stage. So Justice Masley, can you set the stage for us? What is the issue regarding the shortage of judges in New York State?
Sure. Thank you. Thanks, everyone. Especially thanks to those who read the report. And a special thanks to my colleagues who have worked, we've worked together for a very long time on this report. And I certainly hope it makes a difference. Before I talk about the delays, I just want to talk about where I'm coming from. You know, as James said, I'm in the commercial division since 2017, where I have 350 cases now. There are times that I go over 400 of, you know, the most complex commercial cases in the country. Before that, I was in a guardian housing part of the Supreme Court. And before that, I was in family court, where I had over 1,300 cases from 2008 to 2011. So I've been away from family court for a little while, but I do keep in touch with my colleagues there. So I will say that while I had 1,300 cases back in 2008, the caseloads have come down significantly thanks to some of the additions that the legislature has made since then. So basically, those are my credentials when I talk about the delays. Talking about, you know, my current cases. As I said, I have 300 cases. Parties are waiting months. I work really hard. My colleagues work really hard, but people are waiting months for decisions. Personally, I like to write decisions, which takes a lot longer, but you know, we do decisions off the bench as well to try to move our caseloads. But you know, we're doing everything we can to move them, but we are still backlogged. You know, while I have 300 cases, and there are certain parts of the court that have lower caseloads, matrimonial, commercial, the guardianship part has lower cases at times, or less cases. Many of my colleagues here in Supreme Court have over 1,000 cases on their dockets. You know, another example of this delay, I sent a case to the special referee. You know, we have the assistance of these lawyers called special referees. I sent a case, you know, like an attorney's fees hearing, which we send all the time. I sent it in January. It was assigned to a referee in September. They're backlogged. So even the people who are here to help us do discrete trials, you know, they're backlogged too. When I was in family court, custody trials would take over a year to do a custody trial because of the shortage of 18Bs, and our calendars were packed. The judges' calendars were packed, the 18Bs, and now there's a shortage of the 18Bs because of the salaries. So it's all interconnected. And finally, I would say currently, we see delays in an appellate division where a lawyer told me recently he was waiting 3 years for an argument date. And one young lawyer took 2 years. You know, now some of this is due to COVID and catching up. But, you know, and that's certainly true with regard to my trial calendar. My calendar is filled with trials from every month, 1 to 4 weeks a month, from now until February 2025. I'm not the only one who's scheduled out to 2025. So there's a few examples of delays, both current and historic.
And Bob Newman, on the criminal side, what have you experienced in terms of delays, if any, with respect to cases that are making their way through the criminal system?
Well, I do a handful of civil cases, even though my primary specialty is criminal practice. And there is one case in the civil term Supreme Court in Brooklyn where I have been waiting for a decision for more than a year. And it's not only in the city. I have a post-conviction motion in the county court in Schenectady County that was also fully submitted a year ago, and I'm still waiting for a decision. But what struck me most about criminal cases when I looked into the annual reports that the Office of Court Administration compiles relating to criminal court is that in last year, there were 86,372 dismissals, 33,383 guilty pleas in New York City criminal court, and only 115 trials. That means that out of cases that survived arraignment in criminal court, approximately 0.1% of those cases were tried. Now, not every case ought to be tried. In many cases, ought to be settled. The parties can agree on the right disposition. Sometimes the defendant wants to plead guilty. Sometimes the prosecutor is unable to prepare for trial within the time limit. But every time an unduly lenient plea offer is made because there aren't enough judges available to try the case, that is not in the public interest. And to me, as a criminal defense lawyer, even more, every time an innocent person is required to plead guilty because he just can't take more time off from a job in order to make possibly dozens of court appearances before the case is reached for trial, that is definitely not in the public interest. So while we don't want a majority of cases necessarily to be tried, we certainly need more than 0.1%, and having enough judges sitting in criminal court instead of being assigned to other courts, as happens now, will be in the public interest and will help do justice.
So what I'm hearing is that on both sides, on the civil side and the criminal side, there really is a problem with shortages of justices or judges and resources to be able to meet the needs of litigants. And on the criminal side, there's a real impact on the ability of defendants to get their day in court. And so, unfortunately, it leads to a lot of pleas. So, the name of the report is Repeal the Cap and Do the Math. And, we've talked about the shortages. Judge Barrett, can you describe for us what is the constitutional cap and the concept of authorized seats versus other types of seats that may be populating our courts, and what is the relationship between that and the shortages that both Justice Masley and Bob have been describing?
I want to say hello to everybody. Welcome, and thank you for tuning in. We go back to 1846, and out of the disarray in New York State courts, there was a constitutional convention which reformed the entire court system and created a constitutional cap, which is simply a limit on the number of Supreme Court justices that can be created pursuant to a population count. Back then, I think it was 1 in 77,000. In other words, one judge per 77,000 population. We fast forward to 1963, and the Constitution now has revised to offer one judge per 50,000 in population. At that time, the population was such that 364 Supreme Court justices were authorized, and that number sadly did not change even as the population changed. We right now have 364 Supreme Court judges, of which approximately 50 or so are in the appellate division. By 2020 standards, by 2020 population standards, we should have 401 Supreme Court judges authorized under the 1 in 50,000 standard. But that's really not the most significant point. Even if we had 401 Supreme Court judges, we wouldn't come close to meeting the responsibilities of providing justice to all. We would not be able to handle anywhere near the Supreme Court caseload. And what has happened as a result is that via a authorization to assign temporary judges in Article 6, Section 26, and the provision to the Office of Court Administration, which was created in 1977, to provide these assignments under the Chief Judge's rules, we have created the acting Supreme Court judges. And the acting Supreme Court judges number currently about 317. So you're immediately aware of the fact that these judges actually exceed the number of constitutional judges assigned to the Supreme Court. Now, the irony, of course, is that these are allegedly temporary judges. The assignments are temporary to meet an immediate need. Just to utilize personal experience, I became a justice of the Supreme Court in 2016. And prior to that, I was an acting Supreme Court judge for approximately 31 years. I was very happy to have that privilege, but at the same time, that was hardly temporary. And really, a significant point is that the use of acting Supreme Court judges has a cascading effect on all the other courts. There are other problems with acting Supreme Court, but I don't think we have the time now to go into that in detail. But perhaps the one that is most notable is that by borrowing judges from the lower courts or from the Court of Claims or from the family court to sit as Supreme Court judges, you deprive those courts of sufficient numbers of judges, and the appointing bodies or the electing bodies do not replace those judges. And because they are quote unquote temporary, they don't count as vacant spots in those courts. So what you have is the question of how many judges do you need? And this is a subject that we're all going to talk about momentarily. How many judges do you really need? And is there a better way, a fairer way, a more constitutional way to provide the judiciary to handle those cases. So if you have right now approximately 627 Supreme Court judges, and we are still laboring under huge delays and huge caseloads that are backlogged, if that's not enough, it's clear that having a population-based cap, which even though it doesn't exist today, the best we could say would be 401 judges, comes nowhere near dealing with that. And that's why the focal point, perhaps the root of causes here, root of causes not only in the Supreme Court, but in the civil court, in the criminal court, in the family court, is the taking away Supreme Court judges instead of having a rational and correct way of counting the number of judges we need and allowing the Constitution not to interfere with that, but rather to authorize the legislature to create the number of judges that we truly need.
Thank you very much. So
James, can I jump in?
Yeah,
just before
absolutely.
we move on to
Yep.
the
Yep.
next topic? There's another source of temporary judges, which are not temporary at all. And that's taking judges from the trial court and the Supreme Court and putting them into the appellate division. So the Constitution also provides for a second way of using temporary judges to help when a presiding justice notifies the governor that there is a need for temporary judges. So currently, the Constitution provides for 23 judges in the 4 appellate divisions. And there are 31 temporary judges. Those temporary judges have come from the trial courts. So we have 31 less trial court judges in the Supreme Court because they're doing the important work of the appellate division. So they also have 8 certificated judges. In addition to that, thank goodness we have this system where we can move, judges. But those judges, those temporary judges in the appellate division have been there, as Steve was saying, many, many years. They don't move back, right? You're in the appellate division, you're not going to move back, and the need continues. It doesn't decrease, or at least I haven't seen it decrease. So I just wanted to add the other source of temporary judges.
And the problem there is that when the judge is moved from this trial court to the appellate division, the cases in the trial court need to be reassigned. And the more times you need reassignments, it inevitably slows the process down.
Right. And so, Judge Barrett brought up the concept of this initially being, these makeshift measures initially being intended to be temporary, but it sounds like they really have now become de facto permanent positions and entrenched. Justice Masley, has it been now your experience that the expectation to become a fully elected Supreme Court justice requires that you go through this rite of passage and serve as an acting first?
I wasn't acting before I was elected to the Supreme Court, and I have to say it's really good training, right? So it certainly serves that purpose, which is important, to be training your judges in the lower courts and seeing how they can do. And I wouldn't say it's a rite of passage, but it's, I guess, the protocol. And for management or administrative reasons, you do want to see how a judge is going to do, but then it can turn into a 30-year, 20 or 30 years. So
I can also,
yeah.
I can throw in a comment on that as well, and that is that I agree with Andrea that it's good training, but it doesn't really, it's not really the way the system functions. We don't generally, pluck acting Supreme Court judges for positions as Supreme Court justices. There are 2 totally different systems of selection. Supreme Court justices come for election, and acting Supreme Court judges come from usually from the lower courts. Sometimes, and the Court of Claims, which is actually expressly created, with the exception just a few judges, to serve as actings. And those are all the function of OCA, making determinations, the chief administrative judge making a determination of who should be elevated into Supreme Court. So it's not like this is a training ground and we have a good system here. What we have here is a system where there are huge inabilities to meet the workload. And so we essentially cheat the system by bringing in judges who are not constitutional judges to do constitutionally mandated work. Now, the acting Supreme Court judges who exist, the 317, are great judges. I mean, they are terrific judges, and there's nothing here in this report that suggests that there's any loss of quality by having acting Supreme Court judges versus elected Supreme Court justices. The issue is the Constitution is the Constitution. There are requirements, and that this is not a way systematically to deal with a problem. I mean, these very same judges might very well be elevated in a different kind of system, which is not the subject of this report. It'll be the subject of our next report. But at the same time, the system requires that justices be elected. That's the Constitution, and that's what should be allowed to be done. We should have a Supreme Court consisting of justices who derive, Supreme Court justices who derive from their authority from the Constitution.
So what I'm hearing, I think what you're saying is there might be a constitutional issue here also with the practice that's in place, because there are judges who are sitting in seats that are meant to be elected as per the Constitution, but 50% of the Supreme Court justices actually have not been elected, but were appointed through these or designated through these makeshift measures. Would you agree with that?
I can't say I agree with it. I haven't thought about it or studied it, but I have to say that the one thing I disagree with is the notion that they're sitting in seats that were, because there are no seats. I mean, there are 364 seats right now, and every one of them is a justice of the Supreme Court. So the acting Supreme Court judges are sitting as Supreme Court judges, but they're not taking seats that should be in the hands, or under the current status, should be in the hands of Supreme Court justices. We're saying that the Constitution should stand down, the legislature should stand up and create these positions enough to deal with the work, at least 637 and probably more like 700, to deal with kind of backlogs in work, because even 637 Supreme Court judges is not enough to do the Supreme Court work. And in the meantime, as a side effect, we're destroying the civil court, the criminal court, and the family court by taking their judges and not replacing them.
Before we move off the constitutional issue, can I just add that there is actually a difference in resourcing between the actings, not in all the courts, but in Supreme Civil, the actings have not gotten the same resources that the elected judges have gotten. They are doing exactly the same work, and many of the actings are doing even more work because they do weekend arraignments and holiday arraignments in criminal court. Even the judges on the civil side are sitting in criminal court on weekends, even though that's not what they do. So, I have a Supreme Court judge typically has a confidential or administrative assistant. Sometimes that's a newly graduated law student or lawyer, and a law clerk. The actings have one law clerk. They're doing exactly the same work.
Do we
And
have,
of course, they can't serve in the appellate division, the actings.
and so is there a sense of how these makeshift measures have impacted the lower courts? I mean, we obviously know we're taking resources from the lower courts, but have you studied or have you looked at, or is there anecdotal evidence of how exactly these makeshift measures are impacting, for example, the civil court?
So the civil court currently, 42 civil court judges out of 120 are actings. So, you know, not quite half, but, you know, think about that. Almost half of the judges that are supposed to be sitting in civil court in, you know, they sit in small claims court. They are handling consumer debt cases. They are, you know, handling very important cases for people in the city of New York, and half of them are sitting in other courts, you know, criminal court, or, you know, as actings. County court judges, 44 out of 129 are actings. Family court, 57 out of 159. Now, part of that is because upstate, they're sitting in 2 different courts at the same time. So they're not entirely out of family court. They sit in family court and another assignment, which just, needs a Supreme Court designation. Lower criminal court, 69 out of 107 are actings. Court of Claims, 59 out of 86 judges are acting supremes, as Steve said, by design, since the Rockefeller drug laws, positions were created in the Court of Claims to be immediately become acting Supreme Court judges. So, so yes, there is an impact, a very big impact in the lower courts, by moving judges, and you know, because the Supreme Court needs them. You can create more seats in the Court of Claims. The legislature can create more seats in civil court. All of the courts, all the other courts, you can add seats to, but not Supreme, because of the cap. And so this is how we see the cap pushing down on just not just Supreme Court, but on the lower courts also. That's why the cap affects all the courts.
Other reports have gone into the family court in more detail, but I do want to mention that the family court is historically under-resourced. You're going to have a child neglect case beginning when the child is an infant, and it continues well into the child's school-age years. I've been in family court where a witness testifies for 20 minutes, and then the case is adjourned for a month while the court moves on to another decision, and a single witness's testimony can take 3 or 4 months this way.
So we're actually getting some questions in the chat room, and we're going to try to get to those. There will be a question sort of period at the end, but we'll try to also accommodate some of the questions during the panel discussion. So for those in the audience, please definitely keep the questions coming, and to the extent that we can get to them, we will. So one of the questions actually that has come in related to what we're talking about now about the cap is, how many counties are at the cap? Is it more than the New York and the Bronx?
I would refer participants to Exhibit 4, which to the report, which shows you know, what the current population is. And by the way, this goes by judicial district, not by county. Of course, in New York City, each county is a judicial district, but you know, outside of New York City, you know, we have 13 judicial districts that are made up out of a number of counties. So I would look at that Exhibit 4 to answer the question. Currently, New York County is over the cap by 4. Hold on. Kings County is under. Every other district is under except for New York County, and even with those being over the constitutional cap, we hold on. Yeah, you know, even with those extra judges in New York County, if I can just explain for a minute, New York County, in addition to being one of the counties that has the commercial division, it is one of the counties or courts that are designated in contracts all over the world. So a lot of commercial cases are here, but we are also the place where you have a lot more matrimonial cases from all over the state, because the domestic relations statute has no venue provision. So many cases are brought from all over the state for divorces in New York County. And then we also have a lot more Article 78s in New York County, because so many city agencies are in Manhattan. So population is not connected to the number of cases at all, because we, as I said, we have cases coming from around the world, from around the state, and from around the city in Manhattan. You know, and think about it, and on the criminal side, you know, people come into the city from all over the place to work and to visit. And so population has nothing to do with slip and falls. And, you know, it can be somebody from anywhere. And it's just not indicative of the number of cases that we have.
The exhibits to the report show that it's only some of the really sparsely populated districts upstate, some of which have lost population, that are significantly under the cap.
Well,
In the city is at or near the cap.
is the cap just simply unworkable because it hasn't been updated? I mean, it's population based, so it's one justice per 50,000. If you increase that or change the ratio of the cap so that you have more justices, would that solve the problem?
No.
It wouldn't solve the problem.
No.
Okay,
Sorry,
and why not?
Wouldn't solve the
As I
problem.
just said, it's completely unrelated to population. If you're going to have, you know, slip and fall cases, you know, or any of our cases, it's just, it has nothing to do with population. It's, you know, so we really should be doing what, you know, 27, now 28 other states are doing. California has been doing for 60 years now, of a weighted caseload average, and reviewing it on a regular basis, every 2 years, every year, you know, every couple of years, and assess, you know, what is going on in society. Are our numbers going up? Are they going down? And if it's a trend, you know, for example, we've had over 300 acting supremes for, you know, over 10, 20 years. Clearly there's a need. So, you know, we should be looking at increasing the number based on caseloads, not based on population.
Well,
One of the central aspects of our report is that what's essential here is that you have a statistically based, data-driven, weighted caseload analysis of what is necessary. In other words, you can pick a different number. I suppose if you said we're going to have one judge for every 500 people in the population, which would vastly increase the judiciary, you have a lot of people sitting around reading the newspaper all day, which is not desirable. That's not our objective, is to have way too many judges. The objective is to match the number of judges to the amount of work that is truly being presented. And that's why part of our recommendation is it's necessary for both OCA and the legislature to finalize, to create, whether it's in-house or going out, a system of weighted caseload analysis whereby they compare the amount of time necessary to complete the amount of work we have, the number of hours or minutes even, that the number of judges we have would be able to provide. And this is there's an exhibit number 9 of our report has a very interesting piece about how Indiana addresses this issue of trying to break it down into time frames, how much time is needed for cases and how much time judges can provide. And it can get very complicated because when you analyze what a judge can do, it would be easy, if you have a judge who's, one after another doing buy-busts every day, because that's the same analysis that judge he or she might need, 4 days to do a trial, and you can calculate that pretty easily. But you have judges who have calendars and have long and complicated cases. You have judges who have short cases, complicated cases, simple cases. And so the analysis itself is not a simple analysis. It requires real work, and that's why we say that it's possible you'd have to go outside for experts. But at the same time, when that analysis is completed, you have a fair and accurate connection between the number of judges you need and the amount of work you have to have done. Population-based decisions are guesswork. 1 in 50 is too low, 1 in 500 is too high. And how do you come up with the right number? Come up with the right number by analyzing the necessities presented by the cases and the number of judges you need to deal with those cases.
And that's why our report has 2 parts. First is repeal the cap. The second, do the math, do the kind of analysis that Judge Barrett is talking about.
Right. So and this was a question in the chat room, any idea what the policy reason behind the population-based cap was in the first place?
Yes. If you look at our historical section of the report, you'll see that before the cap, the legislature created a lot of seats. And the judges were not doing, they were kind of fighting over certain cases. They wanted to do certain cases, and so certain other cases were waiting. And so this was a solution at the time to get the number of judges based on what they thought was the best indicator at the time, which was population. And when you think about it, it made sense. I can't remember now exactly when it went into effect. I have it written down.
1846, I think.
I think you're right. So, at that time, population, you didn't have tourists coming in and, having to use our courts for whatever reason. You didn't have corporations then, right? We have all these New York corporations that are using our courts now. It just was a different time, and it was certainly the metric to use at that time. Property disputes make sense to use population. Matrimonial makes sense to use population. You have to be a resident of New York, but it doesn't make sense anymore.
So let's talk about the path forward. One or both of you have made reference to the 49 state survey that the committee looked at. Tell us a little bit about that and what were the key takeaways from that survey?
I urge everyone to read that 49 state survey. I know it's long. You don't have to read it in one sitting, but I urge you to look at it because we learned so much about what other states are doing. And we did put things into the survey, things other than how judges or the number of judges is determined for all 49 states. And the federal courts, I might add, use the same weighted caseload method. So what did we see? Well, there's a lot of variety in how people use the weighted caseload method. There's the NCSC, which is the National Center of State Courts, which we see over and over again being used by many states to do the math for them. So they, bring in NCSC. They don't have the capacity in-house. You know, this is New York. We have a, OCI has a really great department that's keeping our data. You know, we put that off for the next report, what our recommendation would be in terms of who should do the analysis, when they should do the analysis. Many states have commissions with appointments from the governor and from the chief judge and from legislators who work together on setting the weights. If you look at the report that's attached in the exhibits of California, they have such a commission. Another interesting thing about California is that, and again, they've been doing this for 60 years. They prioritize. So I know that some are thinking about what's the expense. Well, you know, while it would be a wash here in New York to the extent that you get acting supremes taking newly created positions, in California, they prioritize the number of judges that are needed and where they are needed most. In other words, this is a very long-term process, and you know, we're not saying create 300 seats tomorrow. This is a long-term process that the legislature would you know, analyze and take into consideration what the budget impact and create positions accordingly. In California, knowing that they're not going to create all of the positions that they need every year, they, in addition to doing the weighted caseload method, prioritize, make a list of where the judges are needed the most, and those are the positions that are created as the legislature is creating new positions.
By the way, I don't want to close this without thanking the number of interns and students who helped put this 49 state survey together. It was a big project.
And some of them are watching, I believe. So thank you for that.
So the report makes some concrete proposals. And Bob Newman, can you tell us what those proposals are? Obviously, repealing the cap is one of the things that the report, you know, obviously makes. What else is the report recommending in terms of a path forward?
Well, the first proposal is a constitutional amendment, which we hope can be passed next year by the legislature, and then again in 2025, so that it could go before the voters. It would repeal the cap and also direct the legislature to periodically consider whether to increase, or for that matter, decrease the number of Supreme Court justices. And together with that, we would ask that the legislature enact a statute setting criteria for that process, considering what Judge Barrett was talking about, not only the number of cases filed in each court, but the complexity of the cases and how long it takes to decide motions and resolve particular kinds of cases. And then to help the legislature in this process, we would amend the judiciary law so that the chief administrator of the courts would compile the necessary data and then make a recommendation to the legislature about where judges should be added and to what extent, while the actual power to create additional judgeships would remain with the legislature as it is now.
You mentioned constitutional amendment. Can you elaborate a little bit more on what that entails? Because it sounded like maybe this was going to be a multi-year process from your description.
It definitely is a multi-year process. A constitutional amendment must, to be put before the voters, must be passed in 2 successive sessions of the legislature. Now, one session is this year and 2024. And then after the 2024 election, then there would be another session of the legislature starting in 2025. Once it gets those 2 passages, then it goes before the voters in a referendum. That's how the existing court system was most recently created through a constitutional amendment. And this would require another amendment. And I think there's a general consensus of everyone who has looked at this that the cap is obsolete and really should be modified or done away with so that we can have as many judges as we need to do justice.
In fact, I think there is actually a bill that's been passed through the Senate called the No Cap Act. I think that was introduced by Assemblyman Alex Boris, proposing that we get rid of the cap. Are you familiar with that?
Yes, I read it today, and it's both our proposal and this bill would eliminate the cap, and the only difference is that ours proposal would be a little more explicit in directing that the legislature do a periodic review of the number of judges that we need.
Assuming that the constitutional amendment actually passes, how do we implement this new structure? Should we keep certain makeshift measures in place? Should there be a limit on them? How are we going to transition into sort of the new context?
The certainly this is a subject of that warrants another 75-page report because there are numerous options available. The use of the actings who currently exist, who I've described before as exceptionally good judges, is one of the things that you certainly want to utilize those people in Supreme Court positions if that's possible. But there are other aspects, other ways in which you can discuss this subject, and I don't know that I don't think we've discussed it enough for us to take a position as members of this committee as to exactly what should be done, except with one exception, and that is the one thing we know is that not only after it's passed, but immediately the appointing bodies should replace the vacant positions in the lower courts, civil and criminal court, family court as necessary. They should fill those out because what you have here by calling the acting Supreme Court judges temporary means that when the statistics and the data is published, you have 105, I think, out of 107 authorized criminal court judges, and that's what they'll list, 107 judges. But in fact, there aren't 107 judges serving in the criminal court. And so once you eliminate the notion that there are temporary assignments, then you're bound to fill the vacant positions, or at least consider them. The curtain that's hiding the fact that there are not 107 criminal court judges is eliminated, and we see. So I think that the one thing we all agree on here is that you can't just leave the situation as it is with respect to the lower courts. The other thing I think that there's a sense of agreement on is you can't just simply say one day, well, 317 acting Supreme Court judges are going back, because there's still a need for more than 600 minimum Supreme Court judges. So as Andrea was suggesting, implementation can be done over a period of time, as in California. I have to end just by saying that we have not resolved this issue in our own minds as a committee, and I don't think there's anything that I can say that would represent our thinking as a final matter.
Can I just jump in with regard to the question of what you're suggesting, James, whether you would abolish the actings? Absolutely not. We absolutely need that, kind of valve, in case there's a sudden change, the legislature passes new legislation that requires more judges suddenly for a short period of time. We see that with certain recent legislation, raising the age, and some other cases, the adult sex abuse cases that come to mind also. But the 49 state survey shows us that many other states have this temporary system of moving a judge from a different court to where there's a need. And I would just bring to your attention Missouri, where if that position is, that temporary position is in effect for 3 years, the legislature has to consider making it a permanent seat. Clearly, after 3 years, there's a need, right? So, do the math. We've had actings in place for way longer than 3 years.
So let's talk about,
Just to put the exclamation point on that point, there certainly is, of the many avenues we could consider, one would be where the acting Supreme Court judges currently in existence become Supreme Court justices in some fashion or other. That's all I'll say about that.
so let's talk about, another important issue, which I'm sure people are thinking about. How much is this all going to cost? You're talking about potentially creating several new seats, hundreds of new seats. You're talking about putting together a commission to study and assess the needs from a statistical standpoint, from a metric standpoint. What is the cost of all of this? And is there going to be the political will to actually earmark monies in the state budget for an endeavor like this?
Well, I can't speak to the political will, but I would say, at least initially, the net cost, if you were to slowly move acting Supreme Court, or create new Supreme Court seats, and acting Supreme Court judges are taking those seats, that would be net zero, at least initially. It's when you start going above the 364 plus 317, if you do the math and you find out you actually need more than that, that's when you start talking about a budget impact. There's also the issue, Mike Sonberg's, one of his questions was about, the courtroom space and the staffing. Well, as I said, the acting Supremes already have courtroom space. They already have staff. They don't have as much staff as the elected. So we're talking about one more law clerk. So at least initially, the budget impact, I don't think it's as big as people fear. The other part of it is, we didn't have access to an economist or an accountant to do the evaluation and make a projection as to how much it would cost. But this is what the legislature does every year when they go through the budget process, and they make the assessment, as they have been doing for the past few years. The number of Supremes went up 14 in both 2021 and 2022. Do you know that between 1990 and 2019, the number of judges went up by 13 that entire time? Anyway, just as an aside, my point is, the legislature does this every day, all day. They know how to make an assessment of the cost, and work accordingly, create the positions that they will fund. So you'll have to talk to somebody else about the political side.
Well, we're coming toward the end of our time together. So I think we should probably move into sort of our wrap up. I'd like to give each of you sort of an opportunity to give some concluding thoughts on the issues that have been studied and, you know, what's been recommended in the report. Judge Barrett, I know that you authored a proposed method to, for example, assess what the needs are from a metric standpoint, and maybe you can address that time willing. But I'd like to give you know, all of you sort of the last opportunity to give some key takeaways or any thoughts before we conclude.
The proposal or the illustration that I prepared, clearly it's not something we can talk about in any kind of detail now. It's, you know, but the point of it was not to create a system for analyzing number of Supreme Court judges we need in New York. The point of it was to show that there is a process that, other than a population cap related analysis, there is a process by which you can try to relate resources and needs. And there is a way in which you can try to calculate it. It gets a little bit, you have to get your hands dirty, or whoever's doing the analysis has to get their hands dirty by counting the minutes of certain responsibilities and trying to make predictions based on data, on history, on good sense and anecdotal evidence, whatever it's art rather than science, but there is a process by which you can do this. The example I gave was very simplistic, and even then it became a little complicated. So this is something that must be done by people who have real understanding. But that's the point I was going to make, is that as we transition from the population-based assessment of the number of judges, which, as we've argued, makes no sense, into one that is completely logical and based on need and based on the tying of resources to actual demands, we have to perform these tasks. The legislature and OCA have to perform these tasks with the understanding that they are possible. They're difficult, but they're possible. And the result will be not too many judges, not too few judges, but the right number of judges to deal with the work that we have.
That's Masley or Bob. Any final concluding thoughts?
It's been 60 years since the current constitutional cap was created. There have been a lot of changes since then. On the civil side, you have the commercial division, you have the Child Victims Act, creating a new cause of action. On the criminal side, you have new bail laws and discovery laws that create a significant amount of additional responsibilities for judges. We need to update our system of determining how many judges we need in order to accommodate these changes in society and changes the legislature has enacted.
So I have two things. One is there are immediate measures that can be taken. You know, family court and housing court do not have a cap, and those courts should be evaluated as soon as possible using a weighted caseload. And let's just know, even if you can't create all the positions and no one's asking you to create them all at once, but let's just know what is the need. How many judges do we need in housing court? How many judges do we need in family court? And secondly, you know, the bill pending in the legislature is a great first step, but let's go, because it takes 3 years to get this through, and it's got to go in this legislature because, of course, it has to be 2 different legislatures that it gets approved in, and then it goes on the ballot. But also, you know, while it's nice to just take one provision and strike one line, it's not enough, because we need to know what the need is. You can't just, you know, increase. I guess you can. We've been doing it for years, you know, based on the perception of what's needed in this county or that county. But, you know, with the data-driven society that we live in today and all the data that OCA has been collecting, we should be able to figure it out. And, you know, the data is there if you know how to use it. And I think that the people of the state of New York have the right to know how many judges there should be and how many judges we have and why.
Okay. Well, I want to thank our panelists for a very interesting and thought-provoking discussion. It's been a pleasure, and it's been a pleasure working with all of you in getting this report done and out the door and published after many years. I'm sure that this conversation will continue. It's an important issue and important to our system of justice. And I look forward to working with all of you and anybody else who's interested in improving our system and making sure that we have the right number of judges to meet the needs of our state. So thank you, everybody, for attending tonight. And it's been a pleasure. Thank you.
Thank you.
Thank
Good
you.
night,
Thank
everyone.
you.
Thank-